Now, I am going to dictate a legal passage at the rate of 120 words per minute based on latest judgment of Kolkata High Court. Let's start. The court affidavit in a reply filed by the petitioner in court today is taken on a record. The petitioner is a retired employee of Messrs. Eastern Coalfields Limited within bracket ECL. He retired on attaining his normal age of superannuation on 1st June 2009. The grievance of the petitioner is that though he was appointed on 16th October 1973, the employer has paid his statutory terminal dues on and from January 1978. Due to the same, he suffered financial loss in the calculation of his terminal dues pair. The petitioner raised a grievance before the controlling authority under Payment of Gratuity Act 1972 and order was passed on 13th April 2012. The application made by the petitioner was disposed of wherein the controlling authority came to a specific finding that the date of the appointment of the petitioner is the date from which he was appointed as mining trainee, that is from 16th October 1973. Calculation of gratuity has been made on and from 6th October 1973. The petitioner submits that 16th October 1973 should be treated as his date of appointment. For all purposes, the employer ought to calculate his other terminal dues, that is provident fund, leave encashment on and from the said date pair. The petitioner raised his grievance before the respondents by a letter dated 29 September 2014 and a reminder in the year 2015. The employer by a communication dated 16th January 2015 immediate the petitioner that he was appointed through offer letter dated 16th October 1973, wherein it has been specifically mentioned in point numbers 1, 7 and 8 that his condition for employment has been differentiated specifically from a regular employee. He was allowed to be marked as mining trainee for the first 3 years, and after completion of 3 years he might be appointed to work as mining shorthand, subject to the availability of vacancy and offering employment by Coal Mines Authority Limited. A mining trainee is not liable to be treated as a regular employee, and opportunities of the regular employee are not available to a mining trainee. It is only after the petitioner accepted the said terms and conditions he was allowed to work as mining trainee. The petitioner was directed to report for regular duty on and from 6th July 1978, and it is from that date the calculation of his terminal benefits has been duly made. The date of appointment of the petitioner was reckoned as July 1978 at the time of his promotion. The respondent have categorically stated that all the dues which were payable to the petitioner on his superannuations has been duly paid along with interest, and no amount is due and payable on account of his terminal dues pair. At the time of admission of the writ petition, it was the specific submission on behalf of the petitioner that the gratuity amount has been duly disbursed in his favor and he does not have any claim with regard to the same pair. These records annexed to the affidavit in opposition clearly mention that all the terminal benefits that were due and payable to the petitioner has been duly paid and accepted by the petitioner without any objection. The petitioner is bound by the terms and conditions as mentioned in his letter of appointment. He cannot claim benefits contrary to the same after his superannuation period. In view of the above, there is no reason to entertain the writ petition. No relief can be granted to the petitioner in the instant case. WP number 339 of 2019 stands dismissed. Para. Urgent photostat certified copy of this order, if applied for, shall be given to the parties as expeditiously as possible on compliance of all necessary formalities. Stop. Thank you.